Yes, Mr. Gleeman.
My Lord's Committee, I had shown the court the position the lawyers had reached at the end of December 1973. The view was taken it would be safer to consult the Secretary of State, although it was recognised, certainly in a memorandum from the Attorney General's office, that that would not always be possible. And again, just to give the court contextual reference to the volume of interim custody orders that are being made at that time, the appellant suggests that the figures were dropping away and it would have been possible for one person to deal with it. But if you go to Ireland and the United Kingdom again, MS page 811, the court can see paragraph 64, reference to the period between the entry into force of the terrorist order, which was 7th of November 1972, and the 31st of January 1973, period just under 3 months. 166 interim custody orders were made, 128 detention orders were made in that brief period. If you look across the page to 812, paragraph 67, you will see again the scale of violence. It records that from February 73 to October 74, the police registered 403 deaths. There were explosions had dropped to less than 1,600 in that period. Shootings were down from 10,000 to 7,000, but there was an increase in executions and kneecappings. In that time period, the court will see at paragraph 69, interim custody orders were made between February 73 and October 74 in respect of 725 individuals. So there were 99 Protestants and 626 Catholics subject to ICOs in that period. And shortly I will refer you to duty and to what the court's view was of the workload for the Home Secretary in respect of what he had to deal with. Well, just by way of reference, bear that point in mind when I come back to duty. Well, this is in the period of 73 to October 74. The court will also see that, as I noted at the outset, the Secretary of State had much more to do than simply make interim custody orders. He was running the governance of Northern Ireland, trying to broker a political settlement between the various factions, and he was trying to restore devolution. One can see that at the bottom of the same page, paragraph 73 of MS 813, which refers to the devolution process, which became effective on the 1st of January 1974. Power sharing was reintroduced. The Northern Ireland Executive came into office on the 1st of January 1974, and the Northern Ireland government contained representatives of both communities, but its life proved to be very brief. In May 1974, Protestant extremist groups combined to organise a politically motivated strike, which brought the downfall of the executive and a return to direct rule from Westminster. So we had a major industrial action paralysing the life of Northern Ireland. It brought the power sharing scheme to an end. Devolution ceased, and during that period, again, the court can see the extent of violence and the number of interim custody orders which required to be made.
Well, if one accepts, as I think one must, that the Secretary of State had a very onerous office to discharge, and that he had multifarious duties to perform, how far does that go in helping us to decide whether or not the legislation should be interpreted in the way that you claim that it should be?
We say the approach is this. The baseline position is Carltona applies. It can be displaced by express words. There aren't express words. It can be displaced by implication. Implication requires analysis of the context.
Yeah.
And that's why I say there is merit in examining this type of context and examining the constitutional context for the Secretary of State. When one marries that with the scheme that applied from April 72 through to the making of this order, we say that there's no basis for implying that the Carltona principles are ousted completely, which is what the appellant's case is. So we say this informs directly the court's interpretation of the 1972 order and Article 4.1. And that's the approach that the Northern Ireland Court of Appeal adopted. Lord Justice Weatherup's decision is predicated on that type of analysis.
Yeah.
Again, we say it's The appellant's case is one implies that in this scenario, the scenario I've described, which is unique in the United Kingdom, perhaps unique in our recent history, one should imply into the scheme the obligation for the Secretary of State to personally make every single interim custody order in this context. That's the point that's being put to this court.
Yes.
And we say that's on proper analysis, not tenable. The appellant seeks to gain support for that proposition by reference to what later occurred under Merlin Rees's tenure in the Labour government of 1974. And as I've indicated, the context was changing. He took office in March 1974, halfway through the power-sharing executive. It subsequently failed in May 1974, and we've seen that legal advice was being traded in July 1974 by the Attorney General's Counsel, Mr. Hutton, about these particular provisions. That's the context in which that took effect. And the court's seen the opinion of Mr. Hutton. I won't take the court back to it, but that in itself was the subject of further consideration by the law officers. So it wasn't a definitive view of the law officers, and indeed it wasn't a definitive view of the Secretary of State. And again, if we can go to some more of the archived documents, with apologies, I won't take the court's time with too many more of these, but the Hutton opinion informed the question of whether or not the prosecution of Mr. Adams should proceed, because the Director of Public Prosecution sought advice and direction from the Attorney General in London as to whether or not this should proceed. And one can see that the source materials here are at MS 202 of the core volume. So it's a request from Mr. Shaw, who was the Director of Public Prosecutions at that time, to the Attorney, referencing the opinion of Mr. Hutton and seeking a view upon it. The Attorney General then is involved in the meeting with the Prime Minister that takes place on the 17th of July 1974. My learned friend, Mr. Doran, opened this document to you. So that's MS 204. But what's worthy of note, we say, in that document, is the observation made by Merlin Rees, or at least recorded, attributed to him at the bottom of the page. The Secretary of State for Northern Ireland said that although he understood it was not legally necessary for him to sign the orders, it was his practice to do so. And he undertook to investigate the practice of the Conservative government and these matters as soon as he returned to Northern Ireland. So the political complexion had changed, but the Secretary of State, in this crucial meeting with the law officer and the Prime Minister, is not saying, I'm required by law to sign every or make every interim custody order. Indeed, he's indicating that there's not a legal obligation to do that. Later, his view is expressed in different ways, but that was his position in that meeting in 1974.
On both occasions, the view was expressed on the basis of legal advice, no doubt, and the question is whether legal advice is right or not.
Yes.
That's for us to consider.
Exactly. This case will not turn on these historical documents, I accept that, but insofar as it's suggested that there was a settled view, we say you can't derive an ought an is, and these empirical documents don't give us the answer ultimately. I agree respectfully with my lord about that. But what they do show is that later statements, for example, there's a 1974 document where the same Secretary of State is saying that only he can make those documents. That's a statement by a minister, Secretary of State at that stage. Equally, that's not definitive. And insofar as my learned friend says, if Mr. Adams' appeal was run in 1976, he must have succeeded. Well, it would have been interesting to see how those documents played in any trial if they were.
Well, I think you accept that these political expressions of opinion can only go a limited way towards informing what the correct legal answer is.
Yes, exactly.
So perhaps we don't need to
multiplying the examples, but
we don't need to dwell too much on them.
The high point, we say, is the recognition by Mr. Rees that he wasn't legally obliged, we say, to make the orders.
Right.
That process, which of course is directly germane to the criminal appeal which we're dealing with, concluded with formal reasoning issued by the Attorney General on the 22nd of July 1974, another difficult to read document at MS 212. The Attorney General has come to the conclusion in the first paragraph, while the matter is certainly not free from doubt, on balance a court would probably hold the requirements relating to the interim custody order are satisfied if a Minister of State or Under Secretary of State has considered the case of the suspected person and signed the interim custody order. In other words, it's not essential the Secretary of State should personally have considered the papers in relation to the particular case. That, we say, obviously chimes with what Mr. Rees said at the meeting with the Prime Minister, and it aligns with our contention about the correct interpretive approach in this case.
Right. Well, we've got the various political views. I think perhaps we can move on to legal analysis.
I think the court probably has seen enough archived material.
That's very interesting stuff.
Well, that's all relative.
As one who lived through the time, being very much older than the participants in this case, but I'm not so sure that it's going to assist us to resolve the difficult legal conundrum.
Can I then, with that observation in mind, turn to a consideration of Cartona and what we say the underpinning concepts are behind the Cartona doctrine. This court is familiar with Cartona. It dealt with it in Burgas. My learned friend has already taken the court to Lord Reid's observations at MS 690 in Burgas. But it is sometimes of utility to go back to the source authority itself, and you will find Cartona at 658 is the beginning of the report, and 661 is the oft recited passage. Cartona was a case not about a delegation or a devolution from a Secretary of State, but from a Minister of State to officials, and the themes that can be taken from it in paragraphs A to C of MS 661 are about capacity, workload and accountability. So the functions which are given to ministers, constitutionally properly given to ministers because they are constitutionally responsible, are functions so multifarious that no minister could ever personally attend to them. And to take an example there, the duties imposed upon ministers and the powers given to ministers are normally exercised under the authority of the ministers by responsible officials of the department. Public business could not be carried on if that were not the case. Constitutionally, the decision of such an official is, of course, the decision of the minister. The minister is responsible, as he must answer before Parliament for anything that his officials have done under his authority, and if for an important matter he selected an official of such junior standing that he could not be expected to completely perform the work, the minister would have to answer for that in Parliament. The whole system of departmental organisation and administration is based on the view that ministers, being responsible to Parliament, will see that important duties are committed to experienced officials. If they do not do that, Parliament is a place where complaint must be made against them. And what we take from that is, in the context that we've described to you, it is, we say, patently obvious that the Secretary of State for Northern Ireland could not discharge all of the possible functions that lay within his portfolio. But also, insofar as in this scheme and in the previous delegation that took place from April 1972, it was a delegation or a devolution to ministers who were accountable to Parliament. So the underlying propriety that drives the judgment in Cartona, we say, is observed in the Article 4142 scheme, because here we have ministers of state exercising, and in this case it was the Minister of State who exercised the function of making the order. They could properly answer for any issue in respect of that to Parliament. My learned friends say, well, no, it should be a cabinet minister under Cartona, that's what they say applies. And we say, well, look, the obligation of accountability is satisfied by a devolution of responsibility to a Minister of State. The Northern Ireland Court of Appeal gave an analysis of the principles behind Cartona at paragraph 42 of Lord Justice Wetherup's judgment. The court has seen that in the papers, MS 50. It's an analysis that's now adopted in Benyon as an authoritative exposition of the principles that apply in respect of Cartona. You don't need to go to it, but the reference is at MS 1463 of the papers. We do not understand those principles to be...
Sorry, just give me that reference again, please.
In Benyon, it's 1463, MS 1463.
Yes, thank you.
The issue was examined in two cases that went before the House of Lords, and I said I would come to duty, which is the first of those I'll look at. The Court of Appeal decision in duty can be found at Volume 2 of the Authorities, MS 1252. It's the judgment of Lord Justice Stoughton, which is, again, frequently cited as the centrepiece analysis on Cartona. Begins at page 1289, cites Cartona at 1290. Olada Hinde is dealt with at the bottom of 1290. At 1289, you will see the observation made by the court. Letter H, it's absurd to suppose that every power which is conferred on the political head of a department must be exercised by him and him alone. It is in general sufficient that the power is exercised by a junior minister or official on his behalf. We say that's what occurred here. You will see then at 1291, at letter, below letter C, Parliament must be well aware of the great burden that's imposed on senior ministers who not only take charge of their departments, also speak for them in Parliament, attend meetings of the Cabinet and its committees, see to their constituency affairs if they're members of the House of Commons. And one can add to that the catalogue of other features which I've identified for the Secretary of State for Northern Ireland. You'll note the capacity issue that was under consideration there. There were 2,927 mandatory life sentence cases in a period of slightly more than 23 years, an average of 127 a year. In a written answer, the Minister of State said that 274 mandatory life sentences were considered in 1990. Every such case demands serious consideration, and the burden of considering them all must be substantial. I can see nothing irrational in the Secretary of State devolving the task upon junior ministers. Contrast that with the scale and scope of what the Secretary of State for Northern Ireland was faced with in 1973 and 1974. The Court of Appeal, affirmed by the House of Lords, considered it entirely appropriate that these functions in this context, which did go to Liberty, were discharged by a junior minister. And you'll see Lord Justice Stoughton's observation. There could be no objection to the decisions attacked in this case on the ground that they were or may have been taken by junior ministers rather than the Secretary of State himself. And that was affirmed by Lord Mustill in the House of Lords. The references in the first of the Authorities volumes at 743. At letter F, noting a little to add to Lord Justice Stoughton's consideration, a reference to the Olada Hinde case, which I've already referred the court to. Then, at the top of 744. Throughout the statute book, there are innumerable instances where powers are conferred on the minister and where it's perfectly obvious that Parliament contemplated a delegation. We say here it's also so. And just while I'm on the point about other statutory instruments, we had left on the Justices' benches 2 statutory provisions in photocopied form. I apologise that they weren't in the bundle. One is the Serious Organised Crime Police Act 2005. Section 71 identifies provisions in respect of assisting offenders and prosecutions. And you'll see at 71(4), subsection DB, an example of it being personally confined to the Secretary of State for Business, Energy and Industrial Strategy, acting personally. Then we've passed up the Investigatory Powers Act 2016, section 31, power to issue warrants to be taken personally by ministers. The decision to issue a warrant under this chapter must be taken personally by the Secretary of State. And there was one further reference in the Civil Contingencies Act, that's MS 911, which again restricts the exercise of a particular power to a senior minister of the Crown. Further examples of the type referred to by Lord Mustill here of powers being conferred on a minister. But the duty decision, which deals with the liberty issue, read also with the Olada Hinde case, which is a case where there was an express ouster clause, supports the general proposition that we are putting forward. We also rely upon the Golden Chemical Products Limited decision of Justice Brightman in 1976. The court will find that in volume 3 of the authorities, 30, page MS 1341. And this involved a challenge to a winding up petition. The statutory provision is found at MS 1344, which is section 35(1) of the Companies Act, which has the formula where it appears to the Board of Trade, subsequently amended to be the Secretary of State, which is the same formula that appears in Article 4.1 of the 1972 order. And the issue in that case was whether or not the winding up petition had to be a decision made personally by the Secretary of State, or whether or not it could be entrusted to a lower tier minister or official. Justice Brightman's initial view, MS 1348 at letter C, is that Carltona is decisive of the issue, and there is then a consideration of Carltona. Skinner, which is a criminal case in respect of the use of breathalyzer devices. And the argument is crystallised at letter C of MS 1350. Justice Brightman says, the question before me is whether the power in section 35 was such as to require the personal attention of the minister before being exercised. And there's a reference then to the wartime detention cases, Liversidge and Anderson, etc. Of note also is the observation of the court that the consequences of a winding up petition can be devastating. It's not a loss of liberty, but the consequences are far-reaching. And the case was made in that litigation that there were distinctions to be drawn in cases where liberty was at stake. And you'll see how that's dealt with in the section of 1351 from B to F in Justice Brightman's consideration. If there's a true distinction, it must be drawn as a matter of law between powers which the minister must exercise personally and those which can be exercised by an officer of the department. I might well come to the view the power given by section 35 is so potentially damaging it falls into the former category, however burdensome that may be to a Secretary of State personally. But is such a distinction to be drawn? I find no warrant for it in the authorities. Then there's consideration of Skinner, which is a liberty type scenario. And he, at E, rejects the challenge on this. A distinction between a case which involves a serious invasion of the freedom or property rights of the subject and a case which involves a similar invasion that's not serious seems to me to be impossibly vague. And it's a nicely put passage there about the difference in telling night from day. But that we say is an authority which has stood the test of time. It's been frequently cited in the Northern Ireland Court of Appeal in later cases, indeed by Mr. Justice Hutton, then later Lord Chief Justice Hutton, as he was in considering these sorts of cases. So the idea that because there's a potential liberty issue, the decision must be taken by the Secretary of State, personally, we say, is undermined by the decision in Golden Chemical Products Limited. That's been adopted in a series of Northern Ireland Court of Appeal decisions in this context, because there have been quite a number of challenges to decisions which have been made by someone other than the Secretary of State. The court has the judgment in McKernan, 1982 decision, that's MS 1230.
I beg your pardon, one?
MS 1230.
Thank you.
This is a prison rules case where a remand prisoner was removed from normal association and held in segregated conditions. And the question was whether or not that decision should have been made by the Secretary of State rather than a Minister of State. Mr. Justice Hutton dealt with that at first instance. You will see at MS 1235,
I think this went on appeal, did it not?
It did, yes. The appeals in the next part of the Lord. Golden Chemical Products is cited at 1236 at letter D. Mr. Justice Hutton held that a Minister of State can sign the authority on behalf of the Secretary of State. That went on appeal, as my Lord rightly says. Lord Chief Justice Lowry dealt with that. The judgment begins at 1240. And at 1248, letter C, agrees with Hutton, applies Carltona, and accepts that in those circumstances it was appropriate for the Minister of State and not the Secretary of State to make the order applying Golden Chemical Products Limited again. The issue was revisited by the Northern Ireland Court of Appeal in Harper. That's an MS 759. A case heard before Lord Chief Justice Hutton. At this stage, again at MS 780, he notes that the principle taken from Carltona, applied in many cases, refers to McKernan, which I've just shown the court, and affirms again that it was appropriate for the Minister of State and not the Secretary of State to make the order in that case. In 2009, the Northern Ireland Court of Appeal considered a similar argument again in Ree McCafferty, MS 784. This is a case about revocation.
Sorry, the reference?
784.
784, thank you.
It's a revocation of a licence case. Mr. McCafferty had been released from custody and his licence had been revoked by the Minister of State. You see that at 785, paragraph 6. The statutory provision is in the same paragraph. It's section 1.3 of the 1995 Act, and it allowed a Secretary of State to revoke a licence. So it's the same issue, essentially, whether a Minister of State can act in the stead of a Secretary of State. Lord Justice Coughlan gave the judgment of the court. Paragraphs 12 and following rehearse the analysis. The court will see again the familiar authorities of duty, Rada Hindi, are cited.
Well, is your submission that there is no example of the Cartona principle being displaced, save where there has been explicit and unequivocal language to that effect?
Exactly. These are examples of the displaced by implication contention being rejected. Now, they're different, obviously, in different contexts, but there isn't an example of it being displaced by implication.
So it's never been displaced by implication. Although the theory is, or the thesis is that it can be displaced by implication, that in practice has never occurred.
There's not an example of it. It's referred to in De Smith in the 5th edition. It then becomes slightly more equivocal in the 6th and 7th. By the 8th, it's quite a dilute proposition, but there isn't a concrete example of displacement by implication. And we say that's the novel feature of the appellant's case. And that's why they, court will not have missed, are driven back to the argument that there's something fundamentally different here, because this is extrajudicial detention. That gives you the necessary additional ingredient to get this case over a line that no other case has ever crossed. And I'll come back to...
Yes, but if the pure theory is that it can be displaced by express words or by implication, are you telling us that it has never in fact been displaced by implication?
We've been unable to identify any example.
I see. Thank you.
I highlight the 3 Northern Ireland cases because they are all junior minister cases.
Yes.
You'll notice we say it's a consistent feature of the Northern Ireland jurisprudence on the general approach that Secretary of State's functions are not being discharged by officials. They've been discharged by junior ministers who are accountable to Parliament. Mindful as we must be of the fact that we have a slightly attenuated form of governance in Northern Ireland when we have direct rule, because we have ministers who are elected in Westminster constituencies, not in Northern Ireland. So there's a sensitivity about all of this. Our courts have looked carefully at the question of devolution to ministers of state and repeatedly found that it was in accord with constitutional principle.
When you have a case of devolution like that, is it the junior minister who's responsible, or is it still the power being exercised by the Secretary of State?
It's still notionally, conceptually, it's the power being exercised by the Secretary of State, who will still be accountable. The junior minister will be accountable to Parliament as a member of Parliament, but in constitutional terms, it will be the Secretary of State who remains accountable. In theory. The vulnerability that the minister have, which an official won't, is he can be questioned about it in Parliament. He will be held amenable to whatever decisions he makes, which is what Cartona said in 1943 in the paragraph that I've cited to the court.
Thank you.
Right.
There's a point about that, just while we have Harper open, at page MS 789, because you will see Lord Justice Coughlin in the Court of Appeal dealt with something like that in paragraph 19. They draw parallels with the Secretary of State and the Minister of State. Secretary of State has the ultimate responsibility for security of the state. Both he and the Minister have the same concerns for, receive the same briefings about matters of security. Both are subject to the same systems of accountability. Both occupy high office of state. In such circumstances, it's entirely appropriate the Minister of State should be entitled to exercise the Secretary of State decision-making function under the 1995 Act. So the principle my learned friends argue for would run against the grain of 2 decades worth of authority on this issue in our jurisdiction.
But in none of these cases was there a distinction of the kind that we're invited to consider here between Article 4(1) and 2.
Yes, that's correct also. Yeah. Now, I wanted to turn then to the question of the additional ingredient, if there is additional ingredient to change the analysis on the implication. The applicant says this is a form of extrajudicial detention. It is worthy of note that when this was considered by Lord Diplock, and this helps us to view it through a 1972 lens, when he examined this topic and made his report in 1972, which you'll find at MS 1400-1400. He considered the scheme of detention.
1400?
Yes, it begins at 1400.
Yep.
He considers the need for detention at MS 1413. And highlight for the court paragraph 28 of the Diplock report. The report was made in December 1972. Deprivation of liberty as a result of extrajudicial process.
Sorry, page?
Detention. Sorry, 1413.
Thank you.
Paragraph 28. He's referring here to the nomenclature of the Detention of Terrorists Act. It does not mean imprisonment at the arbitrary diktat of the executive government, which to many people is a common connotation of the term internment. We use it to describe depriving a man of his liberty as a result of an investigation of the facts which inculpate the detainee by a impartial person or tribunal by making use of procedure which, however fair to him, is inappropriate to a court of law because it does not comply with Article 6 of the Convention. So he then goes on to describe the safeguards that arise and are related to the 1972 order. And it's important to bear in mind that the 72 order was a scheme with safeguards, unlike the preceding scheme. And Lord Diplock spoke of that in this report, and indeed I think he spoke in the House of Lords debates on the order, because it was not purely arbitrary detention at the whim of the executive. It was a scheme which the European Court recognised in Ireland and the UK had some additional elements and features. And Lady Black, I think, picked up on this in an observation earlier today, but at MS 811 in the Ireland and the United Kingdom judgment, you'll see that the extrajudicial powers in the view of the European Commission on Human Rights, which had examined this issue extensively, appear to have been exercised on a more selective basis and, broadly speaking, in accordance with the following criteria. Extrajudicial orders were served.
Which paragraph are you reading from?
This is paragraph 65, my lord.
Yeah.
Extrajudicial orders were served only on persons suspected of involvement in serious and organised terrorism. They were used solely as a last resort, that is, only in case where sufficient evidence was not available to justify prosecution before the ordinary courts. And they were not used against a person in respect of matters which had been tried and acquitted by an ordinary court, provided it had been possible to put before the court all the relevant evidence. So we need to be careful about jumping to the conclusion that we're examining some extreme form of executive action of the type that Lord Nichols thought couldn't be countenanced in and Home Secretary. He considered to be anathema to the rule of law. And I say that because this scheme was examined by the European Court of Human Rights. There was a derogation in place, as we know, under Article 15, but as part of the same judgment, you will see what the European Court of Human Rights made of it, and that can be seen at MS 862 of the report, paragraphs 212 and through to 214. So in this section there, the court is considering the scheme of detention that applied in that period and considering whether or not the United Kingdom had acted appropriately given its derogation under Article 15. And inviting the court to look to paragraph 213. So from 9th of August 71 to 5th of February 73, the measures involving deprivation of liberty taken by the respondent state were used only against Republican terrorism, and so on. This issue apart, it appears to the court that the extrajudicial measures brought into operation could, in the situation described above, reasonably have been considered strictly required for the protection of public security, and that in the context of Article 15, their intrinsic necessity, once recognised, could not be affected by the restriction of their field of application. So the European Commission and then the European Court having examined these provisions contextually, were of the view that the United Kingdom had not overreached the scope of its derogation. So the derogation itself, Mr. McLaughlin helps you with that, can be found at, for your note, MS 1456, and that's the derogation at 1457, which relates specifically to the Detention of Terrorists Order 1972. And then the 73 Act is also the subject of derogation. So the European Court looked at all of this and looked at the scheme of detention and expressed its view about that. So it is, we say with that in mind, one turns back to the submission made by my learned friend in reliance upon Lord Nichols in A. Lord Nichols said there may be wholly exceptional circumstances where you can justify a form of detention of this type. The European Court seemed to come to that view in 1977 in Ireland and the UK.
But it only tells you that they said it was necessary in the circumstances. It doesn't tell you that it remains out of the ordinary. And that's the foundation for the submission that's being made, that therefore the Carltona principle ought to be ousted more easily in this setting. Because is there any other known example of Carltona operating in an extrajudicial detention context?
Sure, I can answer that off the top of my head, but we can reflect on that.
Well, forgive me for saying you must have reflected on it already, have you not? I mean, this is the context in which we're considering whether Carltona applies. And it's a central plank of the appellant's argument that it should be more readily displaced where you're dealing with the liberty of the subject, and that the need for scrupulous attention to the decision is more obviously apparent in those circumstances. Well, in fairness to you, I don't think that I can think of an example of where the Carltona principle has been applied in circumstances where someone's liberty has been at stake. And I rather doubt that there is such an example.
No, although the Northern Ireland Special Powers regime allowed for delegation to a police officer in respect of that.
Yes, it did, but there was no challenge to that, was there?
Not at that time, no. But of course, if one wanted to displace Carltona, and it was considered appropriate to do so, there were ready mechanisms in terms of ouster clauses, some of which I've shown the court.
And of course, in the case of the special powers legislation and its successors, there was explicit provision made that delegation could be made to a police officer. Yeah. So there wasn't any question of the application of Carltona.
Yes.
So that, I don't think, contributes much to the debate. I think my lady's point is, and the one that troubles me or concerns me is, if you're talking about the liberty of the subject and you're asking us to accept that a general provision that is superficially at least personalised to the Secretary of State, that can introduce the Carltona principle so that not only a Minister of State, well, I mean, subject to the refinement that you say is introduced by Article 4.2, but that a minister, a junior minister, or indeed an appropriate person can take this momentous decision to detain an individual, that given that you've got a background of making explicit provision for delegation, that rather tells against your submission that the Carltona principle should be in play in relation to Article 4 of the 1972 order.
Well, my lords have the general submission that Carltona applies. It doesn't require me to argue that into the case. That's the baseline condition. And Carltona applies here. It's for the appellant to show the court that it's been displaced. And
yes, but into that debate must go the circumstance that in prior legislation, there was explicit provision made for delegation of the power to detain. Why was that omitted in Article 4?
Well, the delegation was from the Minister of Home Affairs to a police officer, also
Yes.
called a junior minister.
Right.
It's an entirely different scheme under a devolved scheme of government. You would never have a Carltona type argument in respect of a devolved case. Generally speaking, it doesn't arise.
Yes.
It's only when we have the Secretary of State in play that brings in the Carltona machinery. So the necessity to have delegations doesn't arise. And that's why it would have been odious to include it in the 1972 order. Once you have a Secretary of State and that formula in play, you have the benefit of Carltona. And we say the onus is on the appellant to show how that's displaced by implication against the context that we've described. We recognise that the scheme that operated in 1972, continued in 73 and 75, was one that required derogation from the Council of Europe, and we see that in the papers. But it was a scheme that improved upon what went before. It was a scheme that required a degree of quasi-judicial oversight. The later schemes had a detention appeal tribunal, and it's of note that the Gardner report, which came in as a scheme of reviewing all of this in 1975, which the court has been referred to, begins at MS 1444. It's notable that Gardner, sorry, I've lost this reference. I think my learned friends have cited a passage at the beginning of that report, which is at 144, that's paragraph 121. We draw the court's attention to Gardner's view on the prospective position, that's at 1451, MS 1451, and paragraph 159. So having reviewed this scheme, having reviewed the 1973 scheme, having examined the circumstances, he recognised the deprivation of the liberty of an individual by extrajudicial process is a very serious decision for the government of a civilised democratic country to take, and can be justified only if that individual's continued presence in the community was seriously endangered the general security of the public. We therefore recommend that the sole and ultimate responsibility for the detention individual should be that of the Secretary of State, onerous as that may be. His responsibility should not be capable of delegation to any Minister of State or Under Secretary of State. Looking forward, that was his recommendation. He recommended that and recognised that a detention regime may continue to be necessary in Northern Ireland.
What's the date of this?
That's 1975. You'll see at 160, there's a reference to the public interest, the interest of individuals, but we recommend the creation of a detention advisory board to carry out the investigation of cases of individuals proposed for detention. So Lord Gardner was critical of many aspects of the detention and regime in Northern Ireland at that time, made a recommendation for the future.
Does he make any observations about the contemporary legal position?
Only 121, I think, is a passage where he refers to the present procedures. Yeah. Bottom of paragraph 121 refers to the order being made. It can only be made on the authority.
It can only be made on the authority of the Secretary of State.
Yes.
Usually signed by him, although it can be signed by a Minister of State. That rather suggests that Lord Gardner thought that the argument that is presented today by the appellant was right.
Of course, he's analysing this after Merlin Rees has issued his detention guidance with his view, which the court's already seen was a developing view over time. So I'm not suggesting this answers the question. Indeed, like many things in this case, it points both ways, but we rely on his observation for the future in respect of paragraph 159.
Yes, but it depends how you set that in context. Either it's making it abundantly clear that in the future it should be the decision of the Secretary of State, or that it's saying that there should be a change wrought so that the Under Secretary of State or Minister of State can no longer take the decision. And I think you've got to read you've got to read 159 together with 121, don't you?
Yes, we accept that. I'm opening both paragraphs to the court.
Yes, quite.
And again, one must always sound a note of caution about this kind of legal archaeology. There may be elements of this that we don't see. We don't have the whole fossil all of the time, but we say it's instructive that Gardner in his recommendations foresees a future and a need for detention of this type in Northern Ireland at that time.
Right.
Lords, unless you have other questions, I think those are our submissions.
Thank you very much indeed, Mr. McLean. Mr. McLaughlin? Mr. Doran.
My Lords, my Lady, there has been frequent reference to the power of delegation pre-direct rule. And what does seem fairly clear, and I may have mentioned this earlier, is that the actual power to make such orders under the earlier legislation was in fact exercised only personally by the Prime Minister for Northern Ireland. And that is the relevant reference is at Ireland v UK at MS page 818. And that's a reference or discussion of Regulation 11.2 at paragraph 83, and it refers to the power to make detention orders under Regulation 11.2, and says the respondent government said they were always made on the personal decision before direct rule of the Prime Minister of Northern Ireland or thereafter of the Secretary of State for Northern Ireland or two other ministers. And that is, of course...
As Mr. McLean says in a telling phrase, the archaeology of the legal history only helps us so far. I mean, his urgent submission to us is that the Carltona principle, which was deeply embedded in jurisprudence, has to be the essential backdrop to the appropriate interpretation of Article 4. And the history of what has taken place can only contribute to a limited extent to understanding whether or not it does inform the interpretation of Article 4.
And we do accept Carltona as the backdrop.
Yes.
But of course our argument is that the effect of the legislation is to displace it.
Yeah.
And we say that it's...
Well, what do you say to his suggestion, which I think I've probably largely stimulated from him, that there is no example of Carltona having been displaced by implication?
Well, my Lord, in response to that, it seems to me that the best example is probably the wartime detention cases. Now, I have to accept that the actual decisions themselves predated Carltona. So one doesn't have an adjudication to the effect that Carltona is ousted on the face of this provision. But we deal with this in some detail in our written case. Let me take the court briefly to the relevant paragraphs. My Lord, it's at page 98 paragraph 75 and particularly 76, and we say that the distinguishing of those authorities by Lord Hutton when he was Lord Chief Justice in the Harper case doesn't dilute the analogy with those cases in his earlier opinion. And there is no direct authority for the proposition that those extraordinary powers, similar, we say, to the powers in play in this case, could be validly exercised by anyone other than the Secretary of State. And as the opinion observed, in the cases relating to this regulation, it was accepted by the Crown and was implicit in the judgments that the Secretary of State himself must consider each case. Now, my Lord, just...
These are your paragraph 78 and 79?
Yes, 75 and 76 of
75
the
and 76.
case, and that's at MS page
Yes.
98.
Yes, thank you.
But, my Lord, just looking at a couple of examples from these cases, if one goes to Liversidge and Anderson itself, at page, it's in the authorities bundle 2 at MS 1209. This is just a very brief extract from the judgment of Lord Macmillan. And what Lord Macmillan said was that in the next place, it is relevant to consider to whom the emergency power of detention is confided. The statute has authorised it to be conferred upon a Secretary of State, one of the high officers of state, who by reason of his position is entitled to public confidence in his capacity and integrity, who is answerable to Parliament for his conduct in office, and who has access to exclusive sources of information. In a question of interpreting the scope of a power, it is obvious that a wide discretionary power may more readily be inferred to have been confided to one who has high authority and grave responsibility. And my Lord, at MS 1219, Lord Wright said at letter F, if I am right in my view of the effect of the regulation, the choice can only be the choice of the minister. And then he goes on to say, all that the word reasonable then means that the minister must not lightly or arbitrarily invade the liberty of the subject. He must be reasonably satisfied before he acts. Nevertheless...
But, I mean, you've accepted that Carltona wasn't in play at that time. And of course, probably the whole business of civil servants or ministers of state taking the decision on behalf of the Secretary of State wasn't really an issue in these cases, was it?
Yes, well, my Lord, the Carltona principle hadn't been enunciated in the Carltona decision itself. But,
no, but it's a matter of practical politics, so to speak.
Yes.
The whole issue of whether a duty assigned to the Secretary of State could have been discharged by one of his ministers of state wasn't really in play in these cases, was it?
No, that wasn't the decision based by the court, because it was accepted by all that in fact it was a matter for the Secretary of State to make the decision. So I mean, we say essentially that Mr. Hutton's analogy with those cases was sound. Now, just on this question as to examples of Carltona being displaced by implication, of course, one isn't going to expect to find a plethora of such examples, given that Parliament can say in express terms that it wishes a particular person to act, to make a particular decision. There are some other examples from the papers. If one looks at or suggested as examples, if one looks at the Benyon text, for example, at MS 461,
I don't think it must be something other than 461.
1461.
1461, perhaps.
It is 1461.
Yeah, you're right there. Yes, that's all right.
The text says at footnote 4 there, for an example where the Cartona principle appears to be impliedly excluded, see the Civil Contingencies Act 2004.
Sorry, I haven't
Section-
got that reference just yet.
Sorry.
Oh, for an example where the Kaltuna pin.
Yes, it's 1461. Now again, it's an example without there having been a specific adjudication, but that particular provision is given in the authorities at MS 991.
Sorry, I'm not sure that I quite caught up with the last reference.
Why, I'm afraid.
Apologise, mate. Yes, it's
Benyon starts at page 1460.
yes, and on the next page, 1461, there is a footnote.
Footnote.
It's a pretty cryptic reference, isn't it?
It is indeed, but the text purports to identify a possible example of displacement by implication. And he gives the example of Section 20, and that's a power to make emergency regulations under the Civil Contingencies Act 2004. That's MS page 991.
Let's just have a look at that, please.
Sorry, it's MS
991.
991, thank you.
And what provision in particular?
It's Section 22 and 23. 22 says a senior minister of the Crown may make emergency regulations if satisfied that the conditions in Section 21 are satisfied and that it would not be possible without serious delay to arrange for an order in council under subsection 1.
Well, I just wonder, with great respect to the late Professor Benyon, whether this is a question of implication. If you look at subsection 3,
That's, yes.
it defines the senior minister of the Crown in fairly express terms, doesn't it?
It defines the senior minister of the Crown, but what it doesn't do is to go on to say that the decision can only be made by that person personally. And of course, that's what occurred in some of the examples that have been given of express displacement of Cartona.
Well, I'm not so sure. I mean, if a senior minister of the Crown is defined in a comprehensive way, then that, I think, translates back to subsection 2. And if you don't come within the very explicit categories in subsection 3, I'm not so sure that that it's implicit in the section that you're excluded. And it seems to me to be pretty express, does it not?
Yes, although with respect, my lord, that comes somewhat close to our analysis of Articles 4.1 and 4.2, which we say,
yes, we're being into different territory.
which we say is as close
Yes,
to
right,
express that one can get. My lord, can I just give a couple of other suggested examples?
Of course.
Now, in the article by Mr. Laird at MS 1472. This is the article in which Mr. Laird analyses the Court of Appeal decision. And
So just give me that reference again, please.
that's MS 1472.
Right.
And if one goes to page 1477,
Yes.
text accompanying footnote 26. He says this is towards the bottom of the page. ICOs were distinctive for two reasons, neither of which he says was considered by the court. First, an ICO was issued by the executive. The absence of judicial authorization before an individual could be detained was one of the defining features of the internment regime. The closest modern analogy would probably be control orders and their replacement, terrorism prevention and investigation measures, TPIM. And then if one turns to page 1480, there discussion about control orders. Now, my lords, unfortunately, the relevant statutory provisions aren't within the papers, but they were contained in the Prevention of Terrorism Act 2005, Section 1, and the
1480 seems to be composed entirely of footnotes, is that right?
yes, my lord. So footnote 26 refers to the control order procedure.
Right.
But and I apologise for this, my lord, the governing legislative provisions that deal with control orders aren't contained in
Oh, don't worry
papers.
about that.
We can
Sure,
provide
we
the
can
court with copies.
Get access to those, all right.
But
Can I
I
give?
don't think the statute itself
Yes.
didn't specify the Secretary of State personally, did it?
No,
It's
not
just as a matter of practice, it always was, they always were made by the Secretary of State.
Well, what
Is that how it works?
what the yes, what the statute, the more recent statute, the Terrorism Prevention and Investigation Measures Act 2011 says is the Secretary of State may by notice, a TPIM notice, impose specified terrorism prevention and investigation measures on an individual if conditions A to E in Section 3 are met. And then it goes on to say, in this act, terrorism prevention and investigation measures means requirements, restrictions, etc., that may be made in relation to an individual by virtue of Section 1. And there's a reference to the various conditions in the legislation, and it's said that the Secretary of State has to be satisfied on the balance of probabilities that the individual is or has been involved in terrorism-related activity.
Sorry, do we have that?
Fortunately, it's not in the
don't.
papers. There are some copies for the court if the court wishes to have them now.
Yes, that would be very helpful.
So that's the Terrorism Prevention and Investigation Measures Act 2011 and the Prevention of Terrorism Act 2005.
Just let's have a look at the text that deals with footnote 26.
Yes.
Where do we find that?
Oh, yes, and that's the point made by Lordship that the control orders were made by the Home Secretary personally, was confirmed by Lord Carlisle in his first report as independent reviewer of terrorism.
Sorry, where we look? Oh, yes.
In which he commented at para 38 that the process for making a control order is rigorous and structured in an appropriate way. So the decisions are very definitely those of the Home Secretary himself, not his officials.
Where does that appear, please?
That's footnote 26.
Yes. My Lord, the original that quote appears at MS page 1480.
Right, I see. So that's Lord Carlisle's report.
Yes, but the relevant statutory provision, well, first of all, was the Prevention of Terrorism Act 2005, which contains the power to make control orders, and that was then superseded by the Terrorism Prevention and Investigation Measures Act 2011.
Yes, but what is the section in the 2005 Act which you say confines this decision to the Home Secretary himself?
It's section 1(2), where it says the power to make a control order against an individual shall be exercisable, except in the case of an order imposing obligations that are incompatible with the individual's right to liberty under Article 5 by the Secretary of State, and in the case of an order imposing obligations that are or include derogating applications by the court on an application by the Secretary of State. Now, my Lord, I would stress that this is simply an example that is being given by someone else as a possible provision in respect of which there is implied exclusion of Cartona. There hasn't been a formal adjudication of that matter. What Mr. Laird says about it, and this is at page 1477, my Lords, Mr. Laird says, although it does not authorise deprivation of liberty, it would nevertheless be doubtful that a court today would countenance an EPIM being made without a secretary satisfied that the relevant conditions were satisfied.
Yes.
My Lord, there is one other example in the authorities from the case of Enahoro, and that's at MS 1300. Concerned the detention of an individual under the Fugitive Offenders Act. Now, my Lord, this was a case in which the court didn't positively decide that the decision had to be taken by the minister himself, but indicated that it was working on that assumption. It's just at the top of page 1311, my Lord. Equally, in certain cases of administrative decisions, there is no power to delegate, and I would assume without deciding it, that here the Home Secretary, albeit the decision whether to sign the warrant may be treated as an administrative decision, has no power to delegate that responsibility. Assuming that, however, I can see no ground, accepting everything that is said in paragraph 6, for thinking that he has delegated to a majority of Parliament or shared with the majority of the House of Parliament what is his statutory responsibility. So it's not a case in which I can say positively there was an adjudication by the court that Cartona had been impliedly excluded, but certainly the court appeared to work on that assumption.
Yeah.
Now, my Lord, the submission on this point began with a reference to the Golden Chemicals Authority, to which my learned friend, Mr. McGleenan, directed the court's attention. And this was a first instance decision in the Chancery Division, and it's very interesting to note the full the contents of the full passage in which the court deals with Cartona. It's at page 1351, and the court says if there's a true distinction which must be drawn as a matter of law between powers which the minister must exercise personally and those which can be exercised by an officer of his department, I might well come to the view that the power given by section 35 is so potentially damaging that it falls into the former category, however burdensome that may be to a Secretary of State personally. But is such a distinction to be drawn? I find no warrant for it in the authorities. And my learned friend went on and referred to Skinner. Now, Skinner, of course, was a case involving the use of breath test equipment. It doesn't exactly square with the nature of the power at issue in this case. But very interestingly, going down the page, the court says, I reach the conclusion that Mr. Muirhunter's submissions have not started to breach the formidable line authority against which they were gallantly ranged, nor do I think that the principle which he advocates is of practical application. A distinction between a case which involves a serious invasion of the freedom or property rights of the subject and a case which involves a similar invasion that is not serious seems to me to be impossibly vague. I am aware that the absence of a precise demarcation line is not, as Mr. Muirhunter reminded me, a practical impediment to telling night from day. But if Mr. Muirhunter's principles were to be adopted, it seems to me that one would be groping in a perpetual twilight, except at the extremes of midnight and midday. And of course, what we say in this case is that we're at midnight. It's very easy to differentiate the power of executive detention from the powers that were at issue in Golden Chemicals, the power that was at issue in Duty, which related to the decision to release a life sentence prisoner at a particular time. It's distinguishable from the power in McCafferty, which concerned a decision to revoke a licence that had been imposed on an individual who had served a period in custody following on from normal criminal process. And it's also possible to distinguish the power from the circumstances of the Harper case, which involved extended detention of a suspect for questioning as a prelude to the criminal process. And the other case cited by my learned friend McKernan, we respectfully say also concerned powers of a qualitatively entirely different nature to the power at issue in this case. Now, my Lord, I think that most of the points have been covered. I just wanted to perhaps go back on a few of the matters raised by my learned friend, and I'm very alive to your Lordship's note of caution about relying on historical documents. And there was a reference by my learned friend to the notes on the clauses of the 1973 bill. And of course, we would say that that passage is in itself not entirely clear. And in any case, the notes on the clauses of a bill before it has passed arguably cannot be used for interpretative purposes. And we say, of course, that the statement of Lord Hailsham, which is set out in our written case, trumps reliance on any such document of that kind.
Well, I mean, there are equivocal references in Hansard, aren't there? The conflicting statements, are there not?
Well, my Lord, the statement by Lord Hailsham in our respectful submission is reasonably clear.
Yes.
The statement by Mr. van Straubenzee in the debate leading up to the 1970s.
I'm old enough to remember that he used to be referred to as Mr. von Straubenzee.
Straubenzee. I'll correct my pronunciation.
No, well, it may be that yours is a better pronunciation, but I just can cull that from my memory, Mr. von Straubenzee.
My Lord, and certainly the reference by my learned friend to the Attorney General cannot properly be of assistance in interpreting the statute. The Attorney General certainly wasn't the sponsor of the legislation as such. And the remarks of Mr. van Straubenzee actually are quite interesting when considered in the round.
Well, I rather doubt that we're going to be able to resolve this interesting but difficult question by the statements made in Parliament.
And Lord Hailsham wasn't right anyway in what he said, because he said the Secretary of State had to be satisfied that the person was involved in terrorism, and he didn't. It had to appear to him that he is suspected of. So,
yes, yes, my lady. Certainly, can I use the word implication? The clear implication of his remarks was that the decision was personal to the
But it rather illustrates the problem.
Secretary of State.
Could I just ask a question on the status in 1973 of notes on clauses? To whom were they provided? Was it just the ministers, or were they made more widely available to members of Parliament?
I'm afraid, my Lord, that I can't give a definitive answer to that question. I would have thought that the document would have been for fairly limited circulation. And certainly the document which we have seen doesn't have the look of a published document as such. There is a little note in square brackets at the end of the consideration of the relevant provision. It does seem to be a document that is for internal consumption.
So it's not a precursor of explanatory notes, which we're familiar with.
Not that I'm aware of, my Lord, although, as I say, I can't definitively answer your Lordship's question. My Lord, the respondent has relied fairly heavily on the fact that it may have been expected that there would be a fairly significant number of applications of this kind, and we haven't shied away from the number of applications that might potentially arise. One point that should be made is that there is a distinction from duty. First of all, the nature of the power itself is different. And I've said enough about that. But one can also perhaps expect that the task expected of the person making the decision is quite different. If one looks at the Gardner report, which has been opened to your Lordships at paragraph 121, it's MS 1444 is the relevant page. And your Lordships, my lady, will recall that paragraph 121 was the paragraph referring to the order being made on the authority of the Secretary of State. At 122, the nature of the decision is described, and the text says, before the Secretary of State can reach a conclusion as to whether or not any of these criteria is prima facie satisfied, police and army intelligence reports and other information are evaluated, graded and summarised by the security agencies and officials in the Northern Ireland office. The information about and allegations against the suspected terrorist are then presented in summary form with recommendations to the Secretary of State. And in my submission, it's likely that the volume of paperwork that actually finds its way to the decision maker is likely to be considerably less than that involved in a decision on early release from custody following on the imposition of a mandatory life
I think it's probably quite difficult to speculate about the enormity or lack of it, of the task confronting the Secretary of State.
I accept that, my Lord. My Lord, I've made a number of points about the serious nature of the power and the extent to which this departed from normal process, and I'm not going to say anything more about that. Can I finish, my Lords, by referring your Lordships to, and my lady, to page 520 of the papers, more by way of raising a point of interest and a matter of submission, but if one looks at page 520...
Well, we've had plenty of those, Mr. Doran.
Yes, I can't resist it, my Lord. It's a letter or a memorandum from the Home Office to the Northern Ireland Office by Mr. Semkin in the Legal Advisors branch of the Home Office, and it's dated 30th of January 1974, and he is talking about the very point before this court, and he says at paragraph 6, if the point should be taken and we were to lose the first round, we should appeal to the Court of Appeal in Belfast, and thence, if necessary, to the House of Lords.
Yes. Well, I can understand why you couldn't resist that particular allusion.
those are my submissions.
Thank you very much indeed, Mr. Owen. Well, we're very grateful to Council for taking us through this historical disquisition of the legal set up in Northern Ireland in the early 1970s. Council, of course, are far, far too young to remember anything about that, but I'm afraid that I'm sufficiently old to be able to remember something of the contemporaneous events. But we congratulate Council on the exemplary submissions and, of course, those who stand silent behind them and who no doubt have contributed significantly to this very interesting case. And we will take it away and struggle with coming up with the appropriate answer. The court is now adjourned.